We turn our attention once again to the city of Brunswick, Georgia, where the federal hate crimes trial of the 3 men convicted of murdering Ahmaud Arbery began today with jury selection. BNC's Dre Clark has the details.
25 potential jurors were questioned this morning, and out of that group, 16 were asked to come back next week. Another group of 25 is being questioned this afternoon, even as we speak. Meanwhile, there really wasn't much discussion about Ahmaud Arbery's race when those 3 men, Gregory and Travis McMichael and William Bryan, were on trial for murder last November in Georgia State Court because the judge would not allow it. But this time around, federal prosecutors will try to prove that race did play a part when they murdered Ahmaud Arbery in February 2020. The prosecution will try and show and share text messages, particularly from the McMichaels, showing how they would use racial slurs in reference to black people. The McMichaels and William Bryan are all convicted murderers after a nearly all-white jury found them guilty of killing Ahmaud Arbery. They have all been sentenced to life in prison. Prosecutors went against the Arbery family's wishes and offered the McMichaels a plea deal last week. If they agreed to plead guilty and admit Arbery's race did play a factor in their decision to murder him, they would receive a 30-year sentence and a transfer from state prison to a federal facility where they would be allowed to serve their time. Both men agreed to plead guilty. However, the Arbery family asked the judge overseeing the case to reject that plea deal, and she did so, saying that she did not agree with the terms of that agreement. And so she did, in essence, reject that plea deal. The McMichaels quickly withdrew their guilty pleas and decided to go ahead and take their case to trial. Meanwhile, this was Ahmaud Arbery's father talking last Friday after leaving court.
I just got one word to say. All we want is 100% justice to our family. That's all we're looking for. God be the glory.
William Bryan was not offered a plea deal because his legal team believes that he will be found not guilty. Bryan told investigators that after Travis McMichael shot and killed Ahmaud Arbery, that he heard McMichael standing next to Arbery's body and using racial slurs. Also, an FBI agent testified that after going through Travis McMichael's cell phone, he found several racial slurs used in reference to black people. So it's clear that prosecutors will more than likely try and use the words of Gregory McMichael and Travis McMichael against them to illustrate to the jury that race, in fact, did play a part in the killing of Ahmaud Arbery. Meanwhile, jury selection begins. The magic number is 36. Once they're able to reach 36 qualified potential jurors, then that number will be cut down to 16, 12 jurors and 4 alternates, and then the trial can begin. In New York, I'm Dre Clark for BNC.
Time to bring in my expert legal panel, starting with veteran prosecutor and BNC legal contributor Paul Henderson and criminal defense attorney Sue Ann Robinson. Good to have you both on tonight. Paul, state prosecutors strategically avoided the issue of race when trying their murder case against these 3, but for federal prosecutors, it's unavoidable because it's necessary. Now, we all know trying hate crimes is known to be difficult, so what will prosecutors need to show, and how hard will it be to prove their case?
Well, hate crimes are always a little more complicated, and unlike the state case that we've already seen, the issue is not so much as who committed the crime, but why they committed the crime. And that's a little more complex for juries to understand and to unpack for them in order to get to guilty. And so one of the charges that prosecutors have to do is explain the why through evidence. And they're going to have to get to that by presenting to them information and evidence in ways that were avoided in the state trial to focus specifically on the scienter, the mens rea, or the state of mind of the defendants in this case. And that's going to be a big difference. I think a lot of what we'll see in terms of just watching these 2 cases and comparing them differently is we will get a taste and a flavor of what the approach is going to be in this case while we have jury selection. And in the state case, we saw that the defense was very aggressive and very much in the face, talking about raising the issue of race, talking about we feel, talking about white people, talking about their pastors speaking about black people. And we're not going to see a lot of those allusions to race in the arguments. And that's going to help define this jury pool in order to get us to the right amount of people to hear the evidence in this case.
Sue Ann, this case is high profile, with media outlets covering every new development, including the withdrawn guilty pleas by the McMichaels. And of course, that can't be revealed to the jury, but could that fact that the McMichaels were about to plead guilty to crimes they're now fighting, can that taint the jury pool?
I don't think it can taint the jury pool. I think them pleading was just a matter of convenience. You know, them saying, you know what, we don't want to go through this, we'll just go ahead and plea, and them also wanting the added comfort of being able to serve some of their time in a federal facility instead of a state facility. If anything, I think it would tell prospective jurors that they are guilty, that if they were willing to take a plea and admit to the crime, and the only reason why it was withdrawn was because the family objected to them taking a plea.
So to that point, Paul, I mean, you're talking to prospective jurors, you're hoping that they're honest in their thoughts, but what if there are jurors in that pool that have information about these two that were going to plead guilty and now are going to fight these charges? Does that help the defense in that these jurors are probably thinking, well, shoot, you were about to plead guilty, why not just find you guilty?
Well, I think that that does help the prosecution. And the bigger issue is, depending on how much they know about what that process is, there's an understanding that in the allocution is also an admission that what they did was because of race. And so if they knew that they were entering into that plea and cutting a deal, they also knew, or should have known, that part of that was contemplated, or part of what was admitted in contemplation of getting that sentence was an admission that there was racist motivation, that they were racist and that they were motivated by, because of, and in part of, by race. And I think that that's really important in a case like this, because it's going to be parceled out, because each individual defendant has to be found guilty collectively and independently in this case. And you're going to hear a lot of argument where they're going to try and parcel out, well, I wasn't really racist, I was just there. Or this may have been racist, but you're taking it out of context. There's going to be a lot of conversation about that throughout this trial that we're going to hear. And so it's going to be interesting to me, how much do jurors know ahead of time about these individual defendants and about the process that they're engaged in?
Sue Ann, let's talk about evidence. We're watching prosecutors in the federal trial of the former Minneapolis officers essentially present the same evidence and testimony as the state's case against Derek Chauvin. Will we see a similar pattern here? I mean, I know that we're at least going to see evidence that may show racial animus on the part of the defendants, something state prosecutors couldn't get into in their murder trial.
I think that the race is the central issue in this case. So they're going to be permitted to show the Confederate flag that was on the McMichael's truck. They're going to discuss the racial slurs that were used, and then they can get into their social media, they can get into their text messages to demonstrate, as Paul Henderson pointed out, their mens rea, what the motivation for the crime was. I think the benefit of the federal hate crime charge is that in this case, all the quiet parts that we couldn't say out loud in the state case are going to come out. The fact that we, you know, as a community felt like this was a modern day lynching, talking about them stalking him in a group, and making that comparison could even be made in this case because a lot of their actions go directly under the definition of lynching, that there was 3 or more people, that they used a safety reason as why they were engaging with Ahmaud Arbery. So I just think the point of the federal litigation is that everything about race that we knew was underlying, and then everything that the defense claimed, this prosecution is going to say that was all pretext. They weren't trying to secure the neighborhood. They weren't trying to make the place safer. They weren't pursuing him for a citizen's arrest. This was about them being a lynch mob and him being chased down because they're racist individuals. And here's what we can look at from their past actions to demonstrate that they would commit a crime that's racially motivated.
So, Paul, what can we expect from the defense? I mean, will we see any of the defendants testify again? Will we see more of a divide between McMichaels and Bryan? I mean, he did claim to have heard Travis McMichael use a racial slur after shooting Ahmaud.
I mean, that's a big thing to have to overcome. At this point, I would not be surprised if one of them did take the stand, although that went so badly for them the last time they took the stand. But in this case, it's an entirely different kind of audience, and it's an entirely different kind of approach in terms of the prosecution. And if they believe that they can sell their narrative that they are not racist, or that any of them were acting in a way that was not racist, then they're more likely to get on the stand. I, however, think that that is ridiculous, and there is very little that they could say or do that hasn't been proven already in court, and by the way, hasn't already been proven by the video that we all saw. So I don't think that they should get on the stand. I don't think there's any justification for anything about any of their behaviors on that day. And you've already started to see the separation from the defendants as they try and distance themselves and say, like, well, I'm not the one that used the N-word. I'm not the one that did this action. But if you look at their behavior collectively and cumulatively, and what drew them to act collectively together was race. What drew them to act collectively together was the animus and the hatred and the feelings that they had about Ahmaud Arbery. And I'm hoping that that's what the prosecution brings up, and they show the distinction to point out to this jury, would they have acted this way if this was a young woman on the street? We can change it and make it about gender before we start talking about race. And I think everyone will see very clearly the same things that we see, that we want the federal government to prove, was that they acted with hate in their heart and malice in their hearts, and that the federal government will not stand for that. And that's a great balance to the murder prosecution that we've already achieved at the state level.